Hey besties, welcome back to the channel. Today we're diving into something wild. The New York Times, a publication many of us grew up trusting as the pinnacle of legitimate journalism, is now playing what looks like a strategic and calculated game in the media. For a long time, if something appeared in the Times, it was basically treated as fact. But as we've matured, and let's be real, as the media landscape has changed, we've learned that even the most respected outlets are capable of getting things wrong. And while media errors happen, the legal bar to actually sue a journalist and win is incredibly high, as it should be. Protecting freedom of the press is essential to a functioning democracy, even when that freedom makes people uncomfortable. Now onto the case between Baldoni and the New York Times. Baldoni is suing the Times over their reporting on a confidential CRD Civil Rights Division document tied to actress Blake Lively, a document filed in California. The Times published details from it and Baldoni took issue with that. But here's the thing. Under New York's fair reporting privilege, media outlets are allowed to report on documents filed with government bodies, even if they're confidential or not yet made public. As long as those documents were officially submitted to a government entity, they're fair game. That's the legal foundation the Times is standing on. Now here's where it gets spicy. Blake Lively is now saying that this CRD document should have been confidential under a protective order. But despite that claim, the Times ran with the story, arguing they were legally within their rights. A few weeks ago, the Times filed a request with the court for what's called a final judgment. Basically, they want the court to make a definitive ruling. Their position is, if Baldoni wants to appeal, let him. If not, let's close this case out and move on. They're clearly tired of being dragged into what they see as a baseless lawsuit. But there's another party involved here, Wayfair. Because they were named in the larger case, they now have a role to play. And under the court's timeline, they had about 3 weeks to respond to the Times request. That deadline is either today or early next week. As of now, the judge hasn't issued a final ruling, which means the New York Times is still technically in the case. Without that judgment, they can't appeal, they can't ask for attorney's fees, and they're not out of the woods yet. So what do they do instead? They make a move that feels like a power play. They head to state court and file what appears to be a new lawsuit. But here's the kicker. That document? It hasn't even been accepted by the court. No index number. There's an actual warning on it that says it hasn't been reviewed by the clerk and may not be valid. And yet somehow this document is being circulated, either through court channels or directly from the Times. And it's being treated like an official lawsuit, even though it legally isn't, at least not yet. What the Times is doing is trying to sidestep the federal court's timeline by going to state court to pursue attorney's fees under New York Civil Rights Law Section 76A, better known as the Anti-Slapp statute. SLAPP stands for Strategic Lawsuit Against Public Participation, and these laws exist to protect people, especially journalists, from being dragged into expensive legal fights simply for speaking out on matters of public concern. Under New York's anti-SLAPP law, if a media outlet wins a case like this, and if it can show the lawsuit had no legitimate basis in fact or law, then they're entitled to recover damages, including attorney's fees. In their filing, the Times claims exactly that Baldoni's case was meritless, had no grounding in fact, and didn't even present a solid legal argument for changing the current laws. And because of that, they say they should be compensated for having to defend themselves. This isn't just about one case anymore. It's about how media organizations are now using legal systems strategically, not just to defend themselves but to go on the offensive when they feel they've been unfairly targeted. The New York Times is clearly signaling that they won't just sit back and take it. They're willing to fight back and use every legal avenue available to protect their reporting and their bottom line. The lawsuit filed against the New York Times falls squarely under what New York civil rights law defines as an action involving public petition and participation. Essentially, the suit was based on a news article the Times published, an article that was clearly communicating in a public forum on a matter of public interest. The reporting was tied to lawfully exercising their First Amendment right to free speech on an issue that undeniably affects the public. Now, according to the Times and backed up by the district court's own findings, Wayfair and its affiliates had no substantial basis in fact or law when they brought, and continued, the lawsuit. That's a key point because under New York's anti-SLAPP statute, when a defendant prevails in such a case, and the case itself lacks merit, they're entitled to recover legal fees and possibly other damages. That's exactly what the Times is now asking for. Here's how they break it down. The district court dismissed all claims against the Times. Even for the claims that hypothetically might fall outside the scope of New York's fair reporting privilege, such as those based on other communications not included in the CRD complaint, the court said they still didn't show any sign of actual malice. That's important because for a defamation claim against a news outlet to stick, you have to prove not just that the reporting was wrong, but that it was knowingly wrong or recklessly published. That threshold wasn't met here. The judge specifically noted that both the CRD complaint and the Times article included a number of messages and documents that strongly suggested the Wayfair parties may have participated in spreading negative stories about Blake Lively. A reasonable reader could easily conclude there was a smear campaign happening, but crucially, that doesn't mean the Times acted with malice. In fact, the court pointed out that many of the texts the plaintiffs claimed were damning didn't actually prove the Times knew the story was false. The judge even suggested the negative stories about Lively could have come from people outside of Baldoni's circle. The Times also gave Baldoni a chance to respond in the article, and they even included context that portrayed him more positively. That, according to the court, worked against any argument of actual malice. In short, the amended complaint failed to meet multiple legal requirements for a valid defamation claim. Beyond that, the court dismissed the false light claim entirely because New York doesn't even recognize that as a legal cause of action. They also threw out the promissory fraud and breach of implied contract claims, saying they were meritless. The supposed contract turned out to be nothing more than an email giving Wayfair and its affiliates until noon to comment on the article, not a binding agreement of any kind. All told, the New York Times says they racked up over $150,000 in legal fees defending themselves. So what they're arguing now is pretty straightforward. They were doing their job, reporting on matters of public interest. Even though they referenced some text messages outside of the CRD complaint, the article still gave Baldoni fair treatment, offered him a chance to respond, and didn't show any actual malice. That's why they believe they're entitled to recover those legal fees under New York's anti-Slapp law. Now look, I'm all for freedom of the press and protecting speech. From day one, though, I've said this lawsuit against the Times never really made sense. It always felt more like a PR move than a serious legal strategy. Going after the Times, of all outlets, is incredibly hard to win. The bar is sky high, and this case never seemed to clear it. That said, I know there are people out there who genuinely believe there was a viable case, especially around whether the Times went too far in using outside text messages that weren't part of the official CRD complaint. There's also some debate about whether the Times clearly distinguished the CRD complaint, which is a legal complaint, but not a lawsuit, in their reporting. At the end of the day, if Wayfair really believed they had a shot, they could have appealed the district court's decision. That's always been an option. But what really stands out here, and honestly feels like legal gamesmanship, is how this supposed lawsuit from the New York Times is being presented to the public. First, the filing hasn't even been formally accepted by the court, yet it's being shopped around like it's official. Second, the Times chose to file it in New York State Court, which raises eyebrows. It looks like a classic case of forum shopping, trying to find a more favorable court instead of going through the proper venue, which in this case is federal court. Why is that an issue? Because in federal court, especially the Southern District of New York, which falls under the Second Circuit, judges have been pretty consistent in not applying New York's anti-Slapp statute, at least not the way it's written post-2020. In fact, it's been a recurring theme that federal courts often refuse to award attorneys' fees under New York's anti-Slapp law, partly because parts of it conflict with the federal rules of civil procedure. So, it does raise a very real question. Did the Times file in state court because they knew they wouldn't get the outcome they wanted in federal court? Legally, the proper way for the Times to request attorneys' fees would have been to file a separate motion in the federal court under Rule 54D, after a final judgment was entered. But the judge hasn't issued that final judgment yet. So technically their request is premature. And the big risk here? Wayfair and its team could file a notice of removal to bring this case right back into federal court, under 28 U.S.C. Section 1441. That rule allows defendants to remove a state court case to federal court if the federal court had jurisdiction to begin with. And in this situation it clearly does, because the original defamation case was filed and decided there. Also, under 28 U.S.C. Section 1367, the federal court has supplemental jurisdiction over any related claims. And this attorney's fees request is very clearly related to the original federal case. Once removed, it would likely land right back on Judge Lyman's desk. He could then rule that this is simply a post-judgment fees issue from his case, and it belongs in his courtroom. What's more, the judge had already indicated in the past that parties like Reynolds, Lively, and Sloan could request attorney's fees through a separate motion, which implies that there's a correct procedure already available, and this state court move sidesteps it. So it just begs the question, why did the Times try to go around it? And if the case does get removed back to federal court, Judge Lyman could reject the motion for fees under Rule 54D, or he might apply it narrowly. Either way, it's probably not the win the Times is looking for. It just seems like a long shot, especially since the proper window to request fees is typically 2 weeks after the dismissal. If they wanted to file then they could have, or they could wait until final judgment is issued. But running to state court instead makes it look like they know they wouldn't succeed under federal procedure. And that's where the optics get even worse. Filing in state court, knowing it may be removed back to federal, feels like a waste of time and resources. It adds more legal fees, more filings, more motions. It slows things down, and it looks like a strategic maneuver rather than a legitimate legal step. Especially since it's already known that the Southern District of New York is notoriously uncertain about how to handle anti-Slapp fee requests under the 2020 changes to the law. Some judges believe the fee-shifting provision is fine, while others argue it conflicts with the structure of federal procedure. So filing for anti-Slapp fees in this district is a gamble from the jump. It's worth noting that even when some judges do award attorneys' fees under the Anti-Slapp statute, they're cautious. Others stick firmly to the view that New York's version of the law isn't fully compatible with federal rules, especially regarding the motion to dismiss stage and how fee shifting is triggered. That inconsistency makes it a risky bet, because at the end of the day the Times, as the defendant, is the one asking the court for something. That means they carry the burden of persuasion. And Wayfair, of course, is going to argue the opposite, that the fees shouldn't be granted at all. Then it's up to the judge to decide whether to allow it. I actually looked into past cases Judge Lyman has ruled on, and in Griffle's S.A.V. he denied a motion for anti-Slapp attorneys' fees. That decision tells us a lot. It shows he's not exactly eager to apply those provisions, especially in federal court. And that's what makes this whole move by the Times feel off. It's like they know their chances are slim in federal court, so they're trying their luck in state court, hoping no one pushes it back. But if Wayfair does remove it, and they absolutely have the legal grounds to do so, it's likely to land right back in the same federal court where these types of motions have already been denied. The judge's decision stated that the defendant's motion for attorney's fees under New York Civil Rights Law Section 77A must be denied. According to docket number 45, Section 7A, a defendant in a case involving public petition and participation can only recover fees by showing that the action was commenced or continued without a substantial basis in fact or law. The New York Times is essentially arguing in state court, although their filing hasn't yet been accepted by the clerk, that the case was pursued without such a basis. However, the judge never ruled the case meritless. When the lawsuit was dismissed, he denied the anti-Slapp motions filed by Leslie Sloan and Ryan Reynolds but left open the possibility to revisit fees if new information showed the case lacked merit. He has already denied fees multiple times and avoided making a definitive ruling on the anti-Slapp statute itself. Much like his reluctance to rule on Section 47.1, he based his dismissal on fair report privilege and the plaintiff's failure to plausibly plead actual malice, but never stated the plaintiffs lacked a reasonable or substantial basis for the suit. The judge seems to avoid these fee decisions unless absolutely necessary, possibly indicating he only awards fees in truly egregious cases. This may explain why the New York Times is going to state court and avoiding Judge Lyman. The whole situation feels premature, and given Judge Lyman's history, he does not appear inclined to award attorneys' fees. It's unclear if Wayfair plans to appeal. They have retained appellate counsel, but success is uncertain. The legal bar to sue a news outlet like the New York Times is very high. Even if the Times published misleading information such as misrepresenting a CRD complaint as a lawsuit, those are relatively minor issues, and the court ruled there was no actual malice. Until an appeals court weighs in, the outcome remains uncertain. The lawsuit itself hasn't even been filed yet, and the proper venue would be federal court, but the parties aren't going that route. If the suit is filed in state court, Wayfair and Justin can simply remove it back to Judge Lyman to make the decision. Overall, it seems like a strategic move by the Times that might backfire, and they likely won't be awarded fees. What are your thoughts on the Times asking for attorneys' fees or their decision to go to state court? Does that make sense to you? Let me know in the comments below. And don't forget to like this video, subscribe to my channel if you haven't already, and hit the bell so you never miss an update. Thanks so much for watching. Bye besties.